Welcome back to Tort Talk with Joe Fantini, Jon and Marc. We're only a couple days before college football season. Go Blue. Joe, who's your team of choice?
Go Cuse.
Syracuse. Marc?
And the Eagles, the most patriotic mascot you could possibly have.
Georgia Southern.
Yes.
Couple days away from college football season. We are ready to go here. We're going to hit the ground running with news this week on AFFF and PFAS. Last week, we talked about CMO 35, set the deadlines to file cases and allowed plaintiffs to file bulk complaints. And since then, over the past week, there's been about 15,000 lawsuits that have been filed, which is a huge, huge piece of news. Joe, have you ever seen anything like this before in mass torts?
Yeah, no, this is unheard of in mass torts. Usually what we see is that a lone pine order comes in after there's a settlement, but I can't remember a case in recent history where the judge pretty much tipped us off that a settlement was in the works and entered such an order. So to give a little bit of background, in about 6-7 years of this litigation, we had about 10,000 total cases filed. After the CMO got filed, in 7 days, we had more than 15,000 cases filed. So an increase of 150% of the cases. I'm expecting another 30 to 40,000 cases filed before we get to September 5th deadline.
That's insane, Joe. So we're talking about September 5th. Today is August 26th. So in less than 2 weeks, you're expecting another 30 to 40,000 filings?
Yeah, that's what I'm thinking. We'll probably see more than 5,000 cases filed a day. We have the holiday weekend coming up here, but I'm sure people are going to be busy filing away.
And how many are they able to file at once with this bulk order?
The bulk order allows you to file 150 plaintiffs in a single complaint. So people are still filing dozens of complaints or even 100 complaints a day. So a lot of cases getting filed, but it's 150 different plaintiffs in one bundled complaint.
Gotcha. So we see this big uptick in filings immediately after we released our episode. Do you feel responsible for this rush of filings, the 15,000?
No, I can't take responsibility for that. That was probably leadership that negotiated that. But I can say that after we released the video last week, I saw a lot of posts on social media referencing CMO 35. So definitely feel good about getting the news out to everybody and trying to help as many plaintiffs as possible.
Can you talk for a second before we move on to the next tort about this litigation specifically and who is being targeted? Because AFFF and PFAS affect both people who were first party exposed and those who were then exposed to the water contamination. Can you just go over a little bit about how those two tranches are kind of divvied up within the litigation?
Originally, when this litigation, the MDL, was formed, we focused on the water municipalities who had claims because they had to update their water systems and the treating facilities. Then the cases really shifted about a year and a half ago to the personal injury cases, and we were focusing on primarily on firefighters who were exposed when they were serving as firefighters over the years. There were actually some cases involving the turnout equipment and the protective equipment firefighters were wearing as well. And then what we've really seen, a large number of these cases, I'd probably say 75-80% of these cases now that are being filed are these water contamination, drinking water cases where people who are in one of these hotspots that have been identified by the EPA, drinking water that we know has PFAS in it, likely it came from the military bases or where the firefighting foam was used. So out here in Philadelphia, where I am, two of the hottest spots that there are right near the Willow Grove Air Force Base. So that is somewhere where they practice the firefighting prevention techniques. The military used it for decades, and that's a really contaminated water source, and that's where a lot of people are getting it from. So most of these cases now are these water drinking cases.
All right, moving on to the next subject, Depo-Provera. So another unique situation where the MDL judge entered an order requiring firms in leadership to file all of their unfiled cases or risk being removed. Why do you think this was done?
Yeah, this is a really unique order that we rarely ever see. I can't recall seeing another one like this, but basically when leadership got appointed, they represented to the court that they were currently representing hundreds or even thousands of potential plaintiffs, but there's been a slow number of filings coming in. We had about 500 cases filed up until the end of July, and then after this order came in, there's been about another 500 cases filed. Basically, firms in leadership have represented that they're holding on to an inventory of maybe 8,000 to 10,000 other cases. So what the judge is trying to prevent firms from doing is inventorying these cases and waiting for the preemption ruling to come down. So at the end of September, we have a hearing on preemption, which is going to determine whether or not the MDL is going to be a viable option or not. And what firms are doing, it appears, is learning from what happened in Zantac, where everybody was super confident about the litigation, having all of the cases in the MDL, and then our experts got excluded and everybody was in a really bad spot. So firms might be slow playing it a little bit, which is totally their option. There's nothing illegal about that. It's filed within the statute of limitations, but the MGL judge wants to be able to manage the litigation better and feels that she's not able to do it without there being all of these cases on file. So really unique situation. We rarely see this. I'm of the belief that the plaintiffs have the opportunity and should be able to file cases where and when they seem fit. But these firms in leadership, they have a little bit of a different responsibility in relationship to the court. So that's why the judge entered the order here to get those filings up. And I think by the end of September, we'll probably see 2,500, 3,000 total cases filed in the MDL.
Very interesting. Quick question for you. In your opinion, what is best practice for how soon you should file a case as part of an MDL after signing it up?
Great question. Lawyer answers, it depends. It's going to really depend on the procedural posture of the case. So in the MDL or in the state court, you have to determine which state law is going to apply, which is going to be a better situation for your client. Then you also have to analyze issues that relate to the statute of limitations, which is how long you have to file a case from when you were injured or should have known you were injured. Statute of repose, which is something similar to a statute of limitation, but begins when the product was first released or sold to the plaintiff, and then also expert considerations. So each case is different. I try to move the cases as quick as possible, get the records that are needed, but that's why you really need an experienced mass tort attorney when you're working on these type of cases, because it's very nuanced, and it's not like you could just file every single case, sit back, and do nothing.
Yeah, absolutely. We're going to be talking about ultra-processed food. So at the last MTMP, this was all the news. And unfortunately, a disappointing ruling came out yesterday from the Eastern District of Pennsylvania, where an order was entered dismissing a lawsuit brought on behalf of a minor who alleged that they developed fatty liver and diabetes from eating ultra-processed food. What can you tell us about this order, and what does it mean for the litigation moving forward?
Yeah, so I actually have really a lot of knowledge about this litigation. At my prior firm 10 years ago, we were even tossing around the idea of bringing forward this type of lawsuit. Ultimately, we didn't move forward with it. And about a year ago, a number of law firms, including Morgan & Morgan, filed a lawsuit in Philadelphia, Court of Common Pleas, the best court anywhere in the country. I might be biased, but they filed the case there, which potentially could have a really favorable jury. The defendants removed the case to federal court. That's how we got in the Eastern District of Pennsylvania. And what we were really waiting on was this motion practice where the defendant sought to dismiss the case, and ultimately it was granted. The judge, in essence, said the plaintiff didn't plead and couldn't prove with specificity what products they ingested, what food caused the harm of those two injuries you mentioned. If this litigation would have gone forward, we were looking at potentially hundreds of thousands of claimants. So this is a real big setback, because we all know, and we're learning more and more each day, how harmful the ultra-processed foods are. But we're probably going to have to tighten up our theories a little bit, establishing that specific causation. But I don't think this is the last thing we heard of this litigation. It's probably going to be a lull for a little bit while, but we'll probably hear more about it in 26.
I'm very interested to see how this unfolds, because what is the crux of this lawsuit? Is it not properly warning the users, the consumers, or children of the risks of these addictive foods, or that they're unhealthy?
Yeah, basically those two parts. They don't disclose, right, what chemicals were in there, how unhealthy it could be, and these injuries that they could cause. So we believe that there's evidence that these companies knew decades ago how harmful these foods could be. And especially say you have an underprivileged minor, right, who's getting benefits or getting food through school. The food that they're provided with is very limited. Their selections are limited. They, in essence, have to eat this specific food, and they're so harmful, and nobody's telling their parents, the supervisors, anybody in charge of them. And then the kids end up eating this food and develop these lifelong diseases that could have all been avoided if they were giving healthy options. So that's basically the idea and the theory behind this case. There's decades of evidence that supports our theory, but it seems like that specific causation is the gap that we're missing, according to this judge.
Yeah, and as a person who has two young, small children, I can say that the advertising towards children for unhealthy food is unending and constant.
Yeah, that's certainly true.
All right, moving on to the next one. Last one for today, the NEC MDL. Recently, we saw the first two bellwether cases in the MDL dismissed. Where does this litigation stand?
Yeah, so two unfavorable rulings out of the MDL. These were bellwether cases. The MDL judge admitted our plaintiff's general causation expert, but in each of these cases, the judge found that there was that specific causation that was lacking, and both of these cases got kicked out. It's unclear if we're going to have a third bellwether case that gets to trial here in the MDL in 2025. It could be in the winter that we see that. So really, it looks like these 700, 800 cases in the MDL, they might be in a little bit of trouble. So the litigation's really shifting now and focusing more on state court venues. So we have Illinois, we have Missouri, and if you guys recall, we saw some really big verdicts previously, a $400 million plus verdict and a $60 million plus verdict. That was in state court. So it looks like the litigation, the attention's going to be shifting there. And that really goes to show why it's so important for the plaintiffs to evaluate the cases, get in front of the correct judges that issue the rulings that give them the best chance to be successful. And that's why plaintiffs always have the MDL, and then we have that backup option in the various state courts.
Yeah, I remember those big verdicts coming down to the end of last year. I think they came like during or right before MTMP, and people were buzzing from that news of the individual verdicts coming down on those NEC cases.
Yeah, definitely. That was all the buzz. And it's interesting, like John was saying, right? The NEC cases were buzzing. These ultra processed food cases were buzzing. Mass tort made perfect. They don't always turn out. Another big one, Tylenol. That was going to be the next big one. Zantac. So it just shows how hard these cases are. These defendants fight us so hard on them. Basically, every mass tort now turns into a bet the company case. So we have to be really selective and keep pushing and fighting against these huge companies that have so much power, so much money, and control so much here.
Yeah, and there's no better place for those of you who are interested in these litigations to get your news every single week. Joe Fantini, thank you again so much for joining us every single week. You can join us here for Tort Talk with Joe, myself, John Robinson, Mark Ryu. We're talking about everything that happens in the world of MDLs and mass torts. Joe, have a great weekend and enjoy your college football.
All right. Thanks, guys. Have a good one.
Thanks, Joe.